I started my practice down in Bennington, and from there I became a staff attorney and then senior staff attorney for the Vermont League of Cities and Towns. And you may have met me there through my work there, or perhaps attended a program that I presented at VLCT over the 9 or so years that I was employed there. After working for VLCT, I was employed by the city of South Burlington as the city attorney, working in-house. And for the last 5 years, I have been on my own in private practice. I represent and advise municipalities across the state of Vermont, helping them run local government. Over the course of the years, I have been a lister myself. I've been a member of my town's select board. I've been the chair of my town's development review board. All of these really on sort of interim basis to help fill out when vacancies arose and there was a need to carry on. Our topic is deed reading and property tax exemptions. I've included in the handouts 2 outlines, one covering each one of the topics that we are going to be addressing. It's confirmed now that my PowerPoint presentation is coming up on the screen for you folks.
Yes, it is.
Excellent. Okay. So my understanding is that the way we are going to handle questions is through the meeting chat function. I would ask that you submit your questions through that. My program has question marks on some of the slides, and that'll be the point at which I ask Terry whether there have been any questions submitted, and we will address those as we can. As I was reviewing my materials yesterday and again this morning, it struck me once again how complex the matter of property tax exemptions is in the state of Vermont, and how detailed much of this material can be. Property tax exemptions are among the most litigated topics in the state. So I think we need to just fundamentally understand at the outset here that we're not going to know everything we need to know about property tax exemptions, but hopefully everyone will have a sufficient awareness and familiarity with the topics and the various exemptions, so that if something comes up in your community, you will know to perhaps ask some questions and do some additional investigation to find out more. So, Terry, is there anything else we need to address before we start rolling on the subject matter?
I just want to make sure everybody knows that this is being recorded for further review later.
Okay.
And I sent along with the link the documentation to this if you want to print it from the email that I sent.
That's right. And my slide presentation will be following the outline of those handouts almost verbatim. So if there's material on a slide and you'd like to have it in print, you can find that in print on those handouts. Okay. So we'll get going now. Hopefully my slide deck is going to roll through. Okay.
Jim, are you able to turn up your volume a little bit?
Turn up my volume. Let me see what. That's mute, so that didn't help. Let's see. I do not seem to be able to do that.
Okay.
I will try and talk louder. How's that?
So everybody should turn up their volume on their computers, and that will help.
And I will move my microphone a little closer to my mouth. Okay, so our first topic is going to be deed reading. And we're going to look at all of essentially the documents that potentially can transfer title and rights to real estate in the state of Vermont. We're going to look at deeds, The three basic forms that we find in the state of Vermont. We're going to look briefly at easements, divorce judgments and probate decrees, trust deeds, executor, administrator, and guardian deeds, as well as leases. Then we're going to look at concurrent ownership, the interests of multiple owners, and the rights of survivorship. That'll include tenants in common, joint tenants, and tenants by the entirety. We'll talk briefly about life estates, and then we will talk about property descriptions and determining acreage. Sorry, here as I have a little bit of difficulty scrolling through them. I'll get this down here. Just a moment. Okay. When we go on to property tax exemptions, we're going to look at the general principles of property tax exemptions. Who makes the determination whether property is exempt? How are the statutory exemptions construed? In what light do we look at them? The time and timing of exemptions when we make the determination. The importance of being consistent in an inconsistent environment. And then we will go through about 20 exemptions that are found in Vermont law, and I will review each one of them, some of them briefly, some of them a little bit more in depth. So, starting off with deeds. In the state of Vermont, transferring title to real estate requires a written document. And that's the first thing that we must understand. The statute that addresses this provides that estates or interest in land created or conveyed without an instrument in writing shall have the effect of estates at will only. An estate or interest in land shall not be assigned, granted, or surrendered unless by operation of law or by a writing signed by the grantor or his or her attorney. So, of course, the first thing that we need to have is a document in writing. If we don't have a document in writing, it creates what is termed an instated will, which means that the grantor, the person giving the property, can effectively revoke that gift or that grant at any time. It's at will. The most common written document that you will see in your land records to transfer title to real estate in Vermont is the warranty deed. You will also see quitclaim deeds and what are termed limited warranty deeds. In other states, quitclaim deeds and limited warranty deeds are actually more common. They are used in conjunction with title insurance. But in Vermont, by tradition, we see more commonly use the warranty deed. The things that distinguish a warranty deed from other types of deeds are the covenants made by the grantor to the grantee. These are the warranties of the warranty deed. There are 4 of them, respectively. The first is that the grantor promises that he has possession of the property. So it is mine and I possess it. The next is the covenant of title. The grantor has title to the property. Not only do I possess it, but I have a lawful legal right to it. There is the covenant against encumbrances. So that means that the title is not encumbered by claims of third parties not disclosed in the deed or in land records, meaning effectively no one else out there other than me has a claim to this property, or no one other than those persons recorded in the deed or in the land records have claim to this property. And the 4th covenant is the covenant to defend. The grantor promises to defend the title of the property against claims made by third parties. So if we look at a warranty deed, what's shown here on your screen is an example. And we're going to walk through this, each element of this deed step by step, so you can understand what it means and what it intends to do. The first part of a typical warranty deed is what's known as the preamble, and it is set out at the outset. And it typically will read something to the effect of, know all persons by these presents that John Doe and Jane Doe, and in this case, they are husband and wife, of the town of Lakeside in the county of Washington and state of Vermont, grantors, in consideration of $1 and other valuable consideration paid to our full satisfaction by the Town of Lakeside, a Vermont municipal corporation in the County of Washington and State of Vermont, grantee. So the most important thing to take away from the preamble clause is understanding who the parties are. We need to keep in mind that the OR party, the grantor, gives the property, is the property conveying the property, and the EE party, the grantee, receives. So the grantor sells the property and the grantee buys the property. Now, then what often happens is that the mortgagor, who is the property owner, gives a mortgage to the mortgagee, typically the lender. So it is the grantor, the mortgagor giving the mortgage and the mortgagee, the bank, receiving the mortgage. So then after the preamble, we will see typical granting language by these presents to hereby give, grant, convey, and confirm unto the grantee, the Town of Lakeside, and its successors and assigns forever. And then we will have a property description. In this case, it is a piece of land in the Town of Lakeside, described as follows. After the property description, we will have what is called the habendum clause, and it will say to the effect to have and to hold said granted premises with all the privileges and appurtenances thereof, and to the said grantee, Town of Lakeside, its successors and assigns, to its own use and behoof forever. So this is the language that grants. And then we find the language that is the typical language for a warranty deed. And we, the said grantors, John and Jane Doe, for ourselves and our heirs, executors, administrators, do covenant with the said grantee, the Town of Lakeside, and its successors and assigns, that until the unsealing of these presents, we are the sole owners of the premises, and then have good right and title to convey the same in the manner aforesaid, that they are free from every encumbrance, and we hereby engage to warrant and defend the same against all lawful claim whatever. From there, we will have the signature block with a date and the signatures of each of the grantors to the property. And under Vermont law, those signatures have to be notarized. So we will have a notary attestation that follows the signature block. So we talked about a warranty deed and the covenants that go along with it. You will also see a quitclaim deed. Use of quitclaim deeds in the state of Vermont is becoming more common all the time. A quitclaim deed passes only that title that the grantor has at the time of making the deed. So it effectively says, regardless of any claims that might be out there, I give only to you what I believe that I have and nothing more. And I make no promises about the title or about claims of third parties to this property. Quitclaim deeds are also commonly used to release claims or interest in property when the grantor is unsure of the quality or quantity of title. So, for example, someone might, an heir might have a residual interest in a piece of property. We've located that heir and we want to make sure that they don't have or make any claim to the property in the future. So we ask them to execute a quitclaim deed releasing that interest. Now, sometimes folks will see a quitclaim deed and say, I wonder why this individual did not give a warranty deed. Well, giving a quitclaim deed does not necessarily mean or indicate that there is any title defect. It is a more common practice and used more commonly every day in conjunction with title insurance. I think that you will be seeing, and we will all see, more quitclaim deeds going forward. So how does it differ from a warranty deed? The preamble is typically going to be the same. The granting language is slightly different in that it will say typically that the grantor remises releases and quitclaims to the grantee. The property description is going to be the same. The habendum clause is going to be the same. The defining characteristic, though, is going to be that the grantors give no warranty. Effectively, the language will be something along the lines of, we have and claim no right in or to the said quitclaim premises. And the signature block will typically be the same. So, a third type of deed transferring property in the state of Vermont that we will see is what's known as a limited warranty deed, or sometimes referred to as a special warranty deed. Limited or special warranty deeds typically look like a warranty deed, but have a different warranty clause. In a limited warranty deed, the grantor will only covenant that the grantor has done nothing to encumber the title and takes no responsibility for the state of the title prior to the time the grantor acquired the property. So, in effect, the grantor says, I don't know what might have happened in the past, but while I owned the property, I did nothing to encumber the title to it. And what you will see is language typically to the effect of, the grantors hereby engage in warrant to warrant and defend the same only against all claiming by or through or under the grantors. I think the fundamental thing that you folks as listers and assessors should take away from this is that while it's helpful to understand the different types of deeds, it's really largely irrelevant for your listing practices. So from your perspective, a warranty deed or a limited warranty deed or a quitclaim deed has the same effect and is each equally effective to convey title. So while it's helpful to know, oftentimes the different types of deeds are a fact that doesn't matter specifically for your listing work. Now, what you will also see out there is our easement deeds. A warranty deed, a quitclaim deed, a limited warranty deed conveys fee title to the property. That is full ownership rights. The former owner generally retains no ownership and gives up all rights to the property or transfers all rights to the property to the new owner. An easement deed generally only conveys a right to use the property for a specific purpose, but the underlying ownership remains unchanged. So an easement deed may grant a right to travel over a parcel of property, and this would be typically an easement for a right-of-way, or it could, for example, convey the right to develop the property, and you might see this in the form of a conservation easement. An easement deed will typically take the form of a warranty deed, which has the covenants of title, but more often will take the form of a quitclaim deed without covenants. A divorce judgment can also convey title to property in the state of Vermont. So if persons who are married are granted a divorce judgment, and that divorce judgment references real estate, that divorce judgment can be recorded in the land records and is effective to convey the property that is included in the judgment. You will also see deeds by or deeds to trust. These are often used for estate planning purposes. A deed by or to a trust can be in any form, so it could be a warranty deed, a quitclaim deed, or a limited warranty deed. One important fact under Vermont law is that Vermont does not recognize the trust as a person, and therefore title to the real estate held by a trust must be vested in the trustee of the trust. And the property can only be conveyed by the current trustee. So you will typically see a deed from the trustee of the trust. John Doe as trustee of the John Doe Trust, for example. And real estate held in trust must be listed under the name of the trustee. You also see deeds by executors, administrators, or guardians. These are persons who are responsible for an estate or responsible for the oversight of an individual. A deed to or from an executor or an administrator or guardian may also be in any form. So it could be a warranty, quit claim, or limited warranty deed. An executor or an administrator of an estate or a guardian may only sell property with a license to sell from the probate court having jurisdiction over the estate or the guardianship. So if we see a deed from an executor or an administrator or a guardian, we would also want to see recorded a license to sell, authorizing the executor or administrator or guardian to convey that property. And that license to sell would come from the probate court. A probate decree from the probate court, a decree of distribution from the probate court can also transfer property of a deceased persons to persons entitled by law or under a will to receive the property. So if an individual dies, if the individual did not make a provision for passing the property in their will and it becomes in a deed, and it becomes part of their estate, then that property can pass through the estate by a decree of distribution issued by the probate court. And you will see that decree of distribution recorded in the land records. We will also occasionally come across tax collector's deeds. This conveys title from a municipality to a purchaser who purchased the property at a tax sale. You will come across corrective deeds, which are correct or clarify a previous deed. Lawyers and property conveyors occasionally make errors. The way that we fix those errors is to go back and issue a corrective deed from the same grantor to the same grantee, correcting the error. You'll also see recorded in the land records on occasion a lease or a memorandum of lease. A lease conveys to a tenant the right to possess and use the property for a term of years, generally so long as the tenant pays their rent and complies with the other requirements of the lease. Under Vermont law, a lease of a term of 50 years or longer, or containing a right to purchase and allowing the tenant to construct a building or make a major capital improvement, requires the filing of a property transfer tax return. So keep an eye out for that. And occasionally parties, or not occasionally, but typically parties will record a memorandum of lease when a lease has a term longer than 1 year. State statute authorizes the recording of a memorandum of lease, which has essentially the basic elements of the lease to put folks on notice of the lease interest. Those basic elements are typically the grantor, the grantee, the description of the property, and the term of the lease. So Terry, do we have any questions so far?
Hi, Jim. It's Deanna Robitaille. So we do have one question in the chat from Jan. Can you confirm that with a quitclaim deed, the name of the grantor is taken off the grand list parcel maintenance?
I can't confirm that. That would be a question that would have to be asked by the folks at PV&R. Okay.
All right. Would you like me to ask Christy to answer that?
Yes, please.
Christy, would you mind answering that question from Jan? I'll read it again. It's, can you confirm that with a quitclaim deed, the name of the grantor is taken off the grand list parcel maintenance?
Yes, I will confirm that.
Thank you. And oh, let me see, there might be a new question here. From Charlie, please confirm that a leasee does not receive a tax bill.
Typically, a lessee does not receive a tax bill. That's correct.
Okay. From Amy, is there a document to use when owned camps are on leased land?
What I'm going to say is what I would expect to see is that the lease for the land may also reference the camp structure. or occasionally what we might have is a bill of sale for the camp structure that is separate from the lease itself.
Okay. And then from Nancy, do all landline adjustments require a PTTR? I think, or boundary adjustments, I think.
I'm going to say that my understanding, typically a boundary line adjustment is going to require deeds. Those are typically going to be quitclaim deeds. I can't recall off the top of my head whether the property transfer statute requires a filing or transfer return for a boundary line adjustment. I'm inclined to say I believe it does, but we'd have to confirm that by reading the statute itself. Christy, would you know the answer to that?
I'm going to say I agree with you 99%.
Exactly.
I'm 99% sure that's the case. And my understanding is pretty much you need a PTTR almost all the time when you're transferring property, you know, referring back to your first statement.
Yes. There are some specific exemptions for property conveyed for utility purposes, easements, highways, things along those lines. But the general principle I think we should expect is that when a deed is filed or recorded, a property transfer tax return must also be recorded.
All right, so that's the end of our written questions, but we do have a raised hand from Susan Guest. If you are willing to take voice questions, Jim?
I will try.
All right, Susan, would you like to unmute yourself?
Can you tell me if you need a PTTR to when they file something from a decree or a divorce judgment order?
I can't give you a positive answer to that off the top of my head. I'd have to go back and review the transfer tax return statute. I'm inclined to say one is required, but again, without going back and looking at the statute, I can't tell you for certain off the top of my head.
Thank you.
All right, Jim.
Are we ready to roll?
Oh, we got a couple more that came in from Phyllis. Do deeds refer to buildings as improvements?
Typically, yes.
All right. And from Elizabeth, recording a divorce decree does require a PTTR.
Excellent. Thank you for that.
And I think the second part of that question would be, does a divorce decree also need a warranty or a quitclaim deed to transact that property, or is the divorce decree with the PTTR sufficient?
The decree with the PTTR would be sufficient.
All right.
I will put one qualifier on that, is that I've seen a divorce decree that did not include a description of the property. And so we had to ask that the party who was recording the decree go back and get a certified copy of the decree that included a property description so that we knew what property was being transferred.
All right, thank you. And I think we're ready to move along.
Okay. So we're going to move on and talk about concurrent ownership, the interest of multiple owners, and what is termed the rights of survivorship. So when we have multiple owners of property, the most common way, the default way in which those multiple owners own that property is as tenants in common. So two or more persons or entities, for example, companies who acquire or that acquire property will take that property as tenants in common unless other provision is made in the deed. A tenant in common has an equal right to possess the property with the other co-tenants. And a tenant in common can convey his or her interest to another person independently of the co-tenants. So This means that if two people own the property as tenants in common, each has an independent authority or right under the deed to occupy essentially any portion of that property equally with the other co-tenant. There's no specific division or area of the property. Each has an independent full right to occupy and use the entirety of the property. And each tenant in common could potentially convey their interest to another party without the permission of his or her tenant in common. So they have an independent right to convey their interest to another person. A creditor can attach the interest of one tenant in common. So if Joe and Bill own property as tenants in common, and Bill defaults on his truck loan, and the lender obtains a judgment against Bill and records that judgment in the land records, that judgment will be a lien and an attachment against Bill's interest in the property. There is no right of survivorship for tenants in common. So if a tenant in common dies, the ownership interest does not automatically pass to the other co-tenant. It has to pass by will by will or through the probate court. If a tenant in common wants to sell a specific portion of the property must be partitioned by a court, and that requires a legal action in which effectively the court divides the property into pieces to allow one of the tenants in common to sell a portion, or two of the tenants in common to sell different portions. Moving from tenants in common, the next type of concurrent ownership is as a joint tenant. Two or more persons, but not entities. This is a right that can only be held by real people. They hold property as joint tenants. Joint tenants have a right of survivorship, meaning that when one joint tenant dies, that joint tenant's interest passes to the surviving joint tenant, by operation of law. And this happens without any need for probate, a decree of distribution, or deed. It is simply by the fact of death and by operation of law, the interest of the deceased joint tenant passes to the surviving joint tenant. The interest of a living joint tenant can actually be transferred, but the person or entity acquiring the interest takes as a tenant in common. So they do not have a right of survivorship. And when you are dealing with joint tenancy, with joint tenants, and you understand that one joint tenant has died, what we would like to see is a death certificate recorded in the municipal land records before the grand list is changed. So if Joe and Bill hold under their deed as joint tenants with a right of survivorship, and Joe passes away, before the grand list is changed, we would like to see something actually officially recognizing Joe's passing, the death certificate, before we go and change the grand list. Similar to joint tenancy is tenancy by the entirety. The difference being that tenancy by the entirety is a right only held by married couples or partners to a civil union. Tenancy by the entirety has the same survivorship as a joint tenancy. So if Bob and Sue are married and they acquire property, they typically acquire it as tenants by the entirety, meaning that if Bob or Sue passes away, the deceased spouse's or partner's interest passes to the survivor by operation of law. And again, we would like to see a death certificate recorded so that we know that this has actually occurred. If two persons acquire title to real estate before they are married or before they entered into a civil union, the property does not convert to tenancy by the entirety automatically. So marriage does not convert property to tenancy by the entirety. The folks have to actually record a new deed to establish the tenancy by the entirety. And the law treats the couple holding the property as a separate legal person so that claims of creditors of one spouse or partner do not attach to the property except the IRS. And if there is a tax lien against one partner to a marriage or civil union, that lien will attach to the entire property and not just to the interest of the one tenant by the entirety. Another concurrent ownership arrangement that we will see is what's termed a life estate. The life tenant under a life estate has the right to occupy and use the property for a measuring life, which is typically their life. So if Al is granted a life estate in property, he has the right to occupy and use the property typically for his lifetime. It could be actually for the lifetime of some other person, but typically it's going to be Al's lifetime. And when that life expires, the life estate ends. Typically, the life tenant cannot sell, lease, or mortgage or convey the property, and the property passes to the holder of the remainder interest when the measuring life ends. So when Al passes away, the property passes by operation of law to that person or those people who hold the remainder interest. That is a standard life estate. We will also see what is called an enhanced life estate, or often this is referred to as a ladybird deed. Under an enhanced life estate, all of the present ownership rights, including the right to sell, lease, mortgage, or convey the property, is retained by the life tenant. This keeps control of the property with the original owner or owners during their lives, but passes the property outside of probate upon their death. This is often both standard and enhanced life estate deeds are used typically as estate planning tools, typically to allow property to pass from one generation to the next. The current owner, typically parents, are allowed to retain the right to possess and use the property for their lives. And then upon passing, typically you will see that the property passes by deed, by law, to the children. Under Vermont law, where property is subject to a life estate, the property is typically listed to the life estate holder. So in our case, it was Al who has the life estate, and the property is listed under Al's name. And typically Al, in our example, will file a homestead declaration if Al is a Vermont resident and the property is his domicile. So that's how life estates are typically treated. Any questions on concurrent ownership, multiple interests?
We do have a couple questions here. So from Jan, life estate have seen both a warranty deed and a quitclaim way down in the weeds of the deed. How to search for the life estate language, or have to search for that life estate language. Could
Yes.
the TTR have an option for life estate? Quitclaim took the grantor off, then she got irritated when she didn't get the tax bill, didn't want her son to get the tax bill. And is there a preferred deed for a life estate, either warranty or quitclaim?
There's no preferred deed for a life estate. You'll see it done in either way, either form. Excuse me. You may often have to search for the life estate granting language with the deed. It may not be readily apparent. You might have to look through it a little bit. Yes. With regard to who gets the tax bill, again, typically it's the holder of the life estate. That's the way it would be done under Vermont law. If the holders of the remainder interest want to get the tax bill, then they're going to have to make some specialist arrangement with the life estate holder. and potentially the town to have that happen.
All right, thank you. And Walter's asking, once an owner passes and is transferred to the remainder owners, how does the listers know this has taken place?
We hope to have a death certificate come forward and get recorded in the land records. You may not know, and it may require some investigation on your part to confirm that the death has occurred.
And then he is asking, what if they are not residences of our town?
Yeah, we need something, okay? And I realize that typically people are not going to record a death certificate in a town in which they are not residents. It's not going to get recorded, but we would want to potentially contact the holder of the remainder interest and ask them to provide that death certificate to us so that we can get the property changed in the grand list.
All right, that appears to be all of the questions for now.
Okay. So we're going to go on and talk a little bit about property descriptions and acreage. The first thing we should understand is that a single deed can be used to convey multiple separate parcels of land. Separate deeds are not necessarily required for separate parcels. It's fairly common to see one deed conveying two parcels or potentially more than two parcels. I've even seen it where we've had one deed convey parcels of land in two separate towns, which can oftentimes be quite befuddling. But the principle that we need to understand is that a single deed can be used to convey multiple parcels. A description of the property in the deed does not have to be perfect to be legally sufficient. The legal standard essentially is that the description is sufficient if the description can be used to identify the parcel being conveyed. And obviously, that's a pretty low legal bar. Are we able, from the description, to be able to identify what the property is or where the property is, what property we are talking about? So long as we can do that, that property description is going to be legally sufficient. And there are multiple types of descriptions used. Sometimes we will talk about prior deeds, references to prior deeds, references to monuments. Those multiple descriptions are often used in the same deed. And each one of those description types has some advantages and some disadvantages, but you will see them all. Oftentimes, and I think probably most typically, especially in older deeds, you will see a description by reference to prior deeds. And it might take the form of something like this: it being all and the whole of the same lands and premises conveyed to John and Jane Doe by quitclaim deed from Harry E. Quimby and Mabel A. Quimby, dated August 8, 1967, and recorded in Book 21, page 433 of the Town of Lakeside Land Records. That is a legally valid and effective property description so long as it references the prior proper deed, if mistakes are made. But saying effectively, I am conveying everything that was conveyed to me is a legally valid and sufficient description of the property. You will also see in deeds descriptions by reference to monuments. Again, these were often done, we will say, back in the day. A monument can be a man-made or a natural item found on the land with described distances and directions between them. Sometimes you will also see references being made to the boundaries of adjoining landowners. So in this case, with the reference to monuments, the description might read, being 1 acre of land, more or less, with the improvements thereon described as follows: commencing at an iron pin set in the westerly boundary of Lake Road at the northeast corner of lands now or formerly of Ed Smith. Thence proceeding generally westerly along the northerly boundary of said property of Ed Smith, a distance of 100 feet, more or less, to a 15-inch diameter maple tree. Well, of course, this deed description was written up in 1890, and the 15-inch maple tree is now either a 40-inch maple tree or it has long since passed. There can be other difficulties. For example, there may likely to have been hundreds of maple trees on the property at that time, so we don't necessarily know which one. Or perhaps the monument to which we referred, in this case maybe an iron pin, can no longer be found because it was graded under when we graded the road. Ed Smith may have passed away and other things happened. So the description by reference to monuments is not preferred, but you will still see it used, and it is very common in older deeds before property was routinely surveyed. You will also see descriptions by references to courses and distances. This is often termed a meets and bounds description. The directions are either by compass direction in minutes, degrees, minutes, and seconds, or sometimes you'll see them by internal or external angles between adjoining properties. These are something, typically they read something along, thence turning an internal angle to the left of 37 degrees, 28 minutes, and 3 seconds. And of course, distances may be measured in feet. Sometimes we will see it also done in older deeds in chains or in rods. So typically with a reference to course and distances, what we're looking at is angles, compass directions, and distances, typically in feet, but also by other measurements. More commonly, all the time, every day, is a description by reference to a survey. The law requires that a deed or other conveyance of land which references a survey prepared after 1988 may be recorded only if it is accompanied by the survey to which it refers, or cites the volume and page in the land record showing where the survey has been previously recorded. So if our deed makes reference to a survey, that survey has to be recorded in the land records these days. And what we'll typically see for a description is something along the lines of the example there, being Lot 4 on a survey entitled Boundary Line Adjustment, Town of Winchester, Westchester, 3035 U.S. Route 2, Westchester, Vermont, dated January 15, 2020 by Anderson Surveyors and Septic Designers, as recorded in map slide 93, map 418 of the Westchester land record. So that allows us to take the deed and the deed description, go to map slide 93 at map 418, and identify lot 4 on that survey. Now, one of the difficulties, and probably one of the primary difficulties for listers when we're talking about property descriptions, is determining acreage. It's gotten better with recorded surveys and your digital parcel mapping, but there are oftentimes significant discrepancies between deeded acreage and the acreage on a survey, or potentially the acreage in a parcel map. The best guidance I can give you is to do your best with the information that is available to you. There is a generally recognized hierarchy of sources for acreage. Typically, a survey by a registered surveyor is the preferred source for determining acreage, followed by your parcel mapping, which generally coordinates and looks at the property acreage across multiple properties. So that has, because of that broader look, has some measure of reliability in it. That parcel map is followed by the deed description. So the deed description itself in that hierarchy is typically given the lowest priority. But what I would advise you to do always is to look at all of the available information, surveys, parcel maps, and deeds, and do your best with the information that you have available to you. Any questions at that point?
Yes, before we go to that question, there was a secondary question and one before we're asking about the life estate notation on the PTTR. And we found that if you look on the PTTR printout in section F for transfer information, F2 is interest in the property, and the code there will refer to whether or not it's fee simple, life estate, etc.
Excellent.
So if you have any questions about that, get in touch with your district advisor and we can point that out to you so you'll know where to find that in the future. We do have a question from Jan. Can someone from PVR confirm it is true that boundary line adjustments require a survey? And I think that we would pose this to you first.
By law, no boundary line. There's no law that says that a boundary line adjustment has to reference a survey. Almost everyone will, because obviously the difficulty is that we don't know where the boundary is precisely located. The way that we determine that location is typically most often through a survey. That survey will get recorded, and then the corrective boundary adjustment deeds will reference the recorded survey.
Okay, so the answer is it depends.
Yes.
So Amy is asking, regarding digital parcel maps, are those considered legally governing as recorded maps and surveys?
No. I have to ask, or I need some clarification about what means legally governing. They typically, I will say that they typically are not in and of themselves legal descriptions, or are not in and of themselves sufficient to determine boundaries or acreage, but are information that can be used in making boundary and acreage determinations. So they're not legally conclusive, but they are evidence and information that can be considered.
All right, and that's the end of the questions for now.
Okay. So we're going to move on to the second part of the presentation. Maybe it might be a good time to just take a little break. 5 minutes, it would be helpful to me before we roll on, if that works for the folks at PV&R, just so I can grab a quick glass of water. And
Yes, that's fine.
would that be fine?
Yes.
Okay. So
Everybody
I've got
a cup of coffee or tea.
Yep. I've got 10:03 on my clock here. And why don't we plan on taking things up again at 10:08, and I'll roll from there. Okay?
That's fine. Thank you.
Thank you. Okay, folks, I'm back. I think it's about time. Are we ready to roll again?
Before we
Yes.
get going, Jim,
Yep.
we do have a couple of comments in the chat. From
Sure.
Jan, just a general comment, many lawyers completing the PTTRs missed the life estate question. Do you have any advice for these listers on that topic?
If the deed indicates a life estate, but the property transfer tax return does not, then I would follow what is provided in the deed. If you have an attorney's office that is repeatedly missing this, you could send them a friendly email and say, hey, we noticed that you haven't been checking this box on the form. It would be helpful for us if you did. But the text of the deed will control over the box checked in the PTTR for your listing purposes.
All right, thank you. And then we have a question from Cy. Do subdivision covenants such as no commercial trucks parked in a driveway or all new houses must be a specific design or be an approved color have a finite life?
Typically, no. Typically, those covenants run with the land. They would continue to run with the land and be enforceable until such point as all parties who have an interest in the land and the parties who have the right to enforce those covenants relinquish them and give them up.
All right, and that seems to be the end of the questions for now.
Okay. So we'll move on now to property tax exemptions. Again, our agenda for this is to talk about who makes the determination whether property is exempt from taxation. How do we look at the statutory exemptions? When is the determination whether property is exempt made? And the importance of being consistent in what I term to be an inconsistent environment. And then we will review about 20 of the more common property tax exemptions in state law. So it is the listers who determine whether property is taxable or tax exempt, at least in the first instance. The lister's decision can be appealed to your municipality's Board of Civil Authority. The taxpayer must grieve the lister decision and appeal to the BCA before the taxpayer can bring a legal action to determine the exemption in Superior Court. And believe it or not, this was not actually known or determined in Vermont law until 4 years ago in 2017. And so what you would see is a process that sometimes skipped over the Board of Civil Authority, going directly to the courts. Other times in some municipalities, the process would go through the Board of Civil Authority, but it's now known under this decision that came down from the Vermont Supreme Court in 2017 that it's listers make the first determination that is then appealed to the Board of Civil Authority. And then if the taxpayer is unhappy with the BCA's determination regarding the exemption, that is then appealed to Vermont Superior Court. Under Vermont law, exemptions are strictly construed. It's the taxpayer's burden to prove eligibility for an exemption. So the taxpayer has the burden to convince you as listers and to convince the BCA or to convince the court that the property is exempt from taxation. And under Vermont law, if there is any doubt about the application of an exemption, it must be interpreted against granting the exemption. So we look at these things with a jaundiced eye. We are not freely granting exemptions, but in fact, relying on the taxpayer to convince us that an exemption is warranted, and we give that very careful consideration. We also need to give recognize that property tax exemptions are not static, meaning that a property that might be exempt today may not be exempt tomorrow, or a portion of the property that is not exempt or is taxable now may be taxable later. So this needs to be reviewed annually. Some properties, depending on the exemption and the use, may require you to go back and check how the property is being used on a year-by-year basis. When do we make the exemption determination? It's the same deadline or the same date as you use for determining value, that is April 1st. The use of the property on that date controls for purposes of assessment and when determining whether the property qualifies for an exemption. So it's how the property is being used on April 1st. The Vermont Supreme Court has said that future use is unavailing. The relevant test is based on the use of the property during the tax years in question. So your taxpayer may say to you, I have these grand plans to use the property as a tax-exempt animal shelter starting in August. Well, I'm sorry, Mr. Taxpayer, on April 1st, it's still taxable. And that's how it remains during the entirety of the year. So we look at the use of the property on April 1st, and the taxpayer's future plans for the property cannot be the basis of an exemption. I recommend to listers to make sure that they are being consistent. Consistency is essential in all listing practices. Always strive to treat similar properties similarly. And also don't be afraid to look outside your town to see how comparable properties are being treated in other municipalities. Ask your fellow listers how they treat this type of property in their municipality. I'll also tell listers to understand an exemption. It is often critical to read the Superior Court and Supreme Court decisions interpreting these exemptions. Property tax exemptions are among the most litigated matters in the state of Vermont. Each exemption typically has a very large body of case law that accompanies it. And so it oftentimes requires that we look at beyond the language of the statute that grants the exemption, but also to the case law that interprets the exemption to see how it is being applied. I also advise that you think strategically about granting exemptions. It is okay if you are not certain to deny the exemption and let the taxpayer appeal that your determination to the BCA. You may then, if you've participated before the BCA, this would be conducted in the context of a quasi-judicial hearing, just along the same lines as an assessment appeal. And so the BCA can make a determination. And then, of course, if the taxpayer is unhappy, that BCA determination can be appealed to superior courts. So think about the process, and when you are making an exemption determination. Any questions on that background information?
It does not appear so.
Okay, so we will go down and start looking at some of these exemptions. So the first one, it's actually two. The first two are property that is exempt because it is owned by the state of Vermont or the United States government. Real estate owned by the state of Vermont or the United States is likely to be exempt even when the property is leased to a private corporation and used for commercial purposes. When we look at the case law, for property owned by the state of Vermont or owned by the United States government, it is the fact of ownership and not the use that determines the exemption. So the situation may be slightly different for real estate owned by a municipality. When we're looking at property owned by a municipality, the exemption depends not only on ownership by the municipality, but also on where the property is located and the use to which the property is put. Typically, property owned by a municipality that is located within that municipality and which is used for municipal purposes, including the provision of utility services, is exempt from statewide education property tax and will be exempt from local municipal property tax. So the key is it owned by the municipality, and is it located within that municipality, and is it used for municipal purposes? If so, it's likely to be exempt. If the real estate is owned by a municipality and located outside its territorial limits, it is generally taxable by the municipality in which the property is located. However, there is a special statutory formula for determining the value of that property, and that statutory formula is found at 32 VSA 3659, and that formula is complicated enough that it's really beyond the scope of what we will discuss today. So the principle from this is to know that typically municipal property in the municipality, which is used for municipal purposes, is exempt. If it's located outside of the municipality, if it's owned by a municipality but located outside the territorial boundaries of that municipality, it may not be exempt. It may be subject to taxation under a special statutory formula. The property is located in the municipality, owned by the municipality, but used for non-municipal purposes. It's probably going to be subject to statewide education property tax. We might see this, for example, where a municipality owns a piece of property and a building, and it leases the building or a portion of that building out to a private enterprise that may run a building or have an office there. That building and that property is likely going to be subject to statewide education property tax. So, another statutory exemption that you should know and be aware of is real property owned by the post of a veterans organization chartered by act of Congress, or a corporation, the members or stockholders of which are members of a veterans post or auxiliary that is used for its purposes. So typically this is going to be property such as a VFW hall or an American Legion post building. Those are typically pretty easy to identify, and we know that those properties would be exempt. It may also include property owned by a corporation whose members or stockholders are members of the VFW or American Legion, which is used for the corporation's purposes and as its principal meeting place and is not leased or rented for profit. So what this means is that oftentimes the VFW itself doesn't own the building, but the building is owned by members of a company that are members of the VFW, in which case that property would also be exempt. Other property that is exempt by statute is real property owned by and used for the purposes of its work by a nonprofit organization chartered by an act of Congress of the United States. There are certain nonprofit organizations that derive their charter, their operational charter, directly from Congress. And property owned by those nonprofit organizations is exempt from Vermont property tax. There are lists of federally chartered nonprofit organizations available online. If you were to Google federally chartered organizations, you will find that list. Common examples that you might come across in your community are property owned by the Red Cross, by the Boy Scouts of America, by the Girl Scouts, or Little League Baseball, which is each a federally chartered organization. There is some case law that goes along with this. One of these organizations must show that the property for which it seeks the exemption is directly and substantially utilized in furtherance of its organizational purposes. So that means, for example, that if the Red Cross owns property in your municipality, to be exempt, that property must be used by the Red Cross for its educational purposes. It could be leased potentially out to another party, but the lease income received has to be used in furtherance of, in our example, the Red Cross's goals. So there can be some wrinkles that go along with that. And we need to understand not only who owns the property, but potentially how the property is being used. Any questions on those?
Yes, we have quite a few.
I'm sure.
From Danny, if town leases land to someone who then rents the property, is that taxable?
What use is the tenant? How is the tenant using the property?
Danny, do you have a microphone? Would you like to clarify?
Yes, I can clarify. There is a property in town that was leased to a gentleman. It's a house, and then on property. And so he then rents out the house.
And it's used for residential purposes.
Yes,
And it's owned by the town, but privately used for residential purposes.
it's owned by the town, leased to a gentleman, and then
Yep.
this gentleman rents it to yet
Okay.
another person.
Okay, it's going to be probably subject to statewide education property tax. It's probably going to, the municipality is probably going to exempt the property itself from the municipal property tax. Because, you know, we're essentially collecting a tax from ourselves.
Yeah.
That property is going to be subject to statewide education property tax.
Thank you. That's driven us nuts for years.
You're welcome.
What about municipally owned forests used for trails?
Located within the municipality or located in another municipality?
Jan, do you have a microphone? Would you like to clarify? Oh, maybe she doesn't have a microphone.
I think I know who Jan is, and I think I know what property we're actually talking about. So a town forest that is located within the boundaries of that town that is made available to the public for recreational use, trails, etc., would be exempt, would be exempt property.
Is there maybe a situation where they are having registration, a paid registration to use the forest?
I would say even if the town forest is generally available to the public, so that any member of the public could potentially register to use it, then it's still going to be exempt. If the town forest were, for example, leased out to a private party for the purposes of, I don't know, let's say operating a mountain bike trail facility in which the public is charged a user fee, then I would say that it is less likely to be exempt.
Okay, thank you.
Yep.
From Amy, I received a call yesterday from the Restore Resale Store, or maybe Resource, in town, which is run by Green Mountain Habitat for Humanity and is a 501c3. Perfect timing for class. They asked how they applied to be tax exempt and would they be eligible for local and state tax exemption. And I think in an answer to that question, Christy Wright included in the chat a link to the PVR form, PVR 317, which is a form that you provide to them to apply for exemption.
Yep. And we're going to talk a little bit about the public, pious, and charitable use exemption that they might qualify under. But again, they would be responsible for completing that 317 form and providing you with the information necessary to make that determination.
Charlie is asking fire districts, ? And that's the entire question. Do you have anything to say on fire districts?
There's a lot to say about fire districts, I suppose. Typically, fire district property is going to be tax exempt, but I'm going to leave it at that.
Okay. Can a legion have more than one exempt property within a town?
Potentially, yes. We'd have to look at how that property is owned and the use to which the property is put.
Okay, and one of my own, if a town has a Grange Hall that they rent out for events, but the amount of the rental is to cover the cleaning of the building, would that be exempt?
The lead into that was a town has a Grange Hall, but I assume what we're saying here is that the Grange Hall is owned by a Grange organization.
No, it's owned by the town.
Okay, if the town owns a building and the town rents that out for individual, use on a, use by use basis, that's still going to typically be exempt. Okay. If the town owned the we'll call it the Grange building, and the town leased the Grange building out to a private enterprise that then utilized the Grange building in furtherance of the activities of that private enterprise, then that property is likely subject to statewide education property tax.
Okay, and that appears to be the end of the questions.
Okay. So we hit some of the easier ones, and now we're going to get into what is probably the most complicated and litigated category of the property tax exemptions in Vermont law. And we're going to try and raise some awareness about this and give you some knowledge about this, but I can't say that we're going to know everything we need to know when we get done with this section. So one of the tax exemption categories is property that is real estate that is granted, sequestered, or used for public, pious, or charitable uses. This is found in 32 VSA 3802 paragraph 4, and it's typically referred to as the public, pious, or charitable use test. So to qualify for the public, pious, or charitable use exemption under Vermont law, the property must meet a three-part test. You will hear this referred to as the American Museum of Fly Fishing test, or the fly fishing test. The first element of this test is that the property must be dedicated unconditionally to public use. The second prong is that the primary use must directly benefit an indefinite class of persons who are part of the public and must also confer a benefit on society as a result of the benefit conferred on persons directly served. And third, the property must be owned and operated on a not-for-profit basis. Now, we're going to unpack this a little bit and look at each one of these elements. And I will tell you, when this decision came down, one of the justices of the Supreme Court wrote a dissenting opinion and said effectively that the Supreme Court had made up a test that no one was ever going to be able to figure out and would result in essentially endless litigation by nonprofit entities against their municipalities going forward. And that dissenting justice was probably pretty close to correct. This is one of the most litigated elements of Vermont law, but we'll do our best to get through it. The legislature has said that the statutory purpose of the exemption for public, pious, and charitable property in this section is to allow these organizations to dedicate more of their financial resources to furthering their public service missions. That's great. And we all understand the concept that money that is not paid as property tax can be used toward the mission of the organization, but nevertheless, we have to sort through this test and give it some understanding. So the first question that we have to ask when we're looking at this exemption is the property dedicated unconditionally to public use? And there's two parts to that. The first is the public use part, and the second is the dedicated unconditionally part. So The Supreme Court has said that public use in this context does not mean that the members of the public must physically use the property. So it's not a case where we have to just open it up to anyone who wants to come and they have to physically be on and use the property. Instead, the property must be put to some primary use that benefits the public. The benefit derived by the public from the use of the property must be direct and immediate rather than remote and incidental. So there has to be a public use here. It's not necessarily that the public must physically use the property, but there must be some use that primarily benefits the public. So the next element is after we look at is it used by the public, or is there a public use of this property? The next we have to look at it is the property dedicated unconditionally to this public use? And so the court has said in determining whether the property has been unconditionally dedicated, legal documents such as the articles of incorporation and corporate bylaws of the entity owning the property may be considered. Oops. So when we're looking at the public, pious, or charitable use exemption, one of the things that we want to see is the bylaws or the articles of the organization of the entity. And what we want to look for in that is language to the effect that the property is owned by the organization, is irrevocably dedicated to the charitable and educational purposes of the organization. That's something that if you look at articles of organization of a nonprofit or a 501c3, you're going to typically see that. You're also going to see language to the effect that upon dissolution, the assets of the corporation will be distributed to one or more domestic corporations, societies, or organizations that are qualified for nonprofit and tax-exempt status under Section 501c3 of the Internal Revenue Code. So it's dedicated to charitable use, and if we give it up, it will go to some other organization that will use the property for public use. You might also find language in deeds or other land records that establish the property is dedicated unconditionally to public use. So if there's a clause in the deed that says this property shall be dedicated or shall be used unconditionally by the public, you're probably going to satisfy the first element of this test. So we're going to, again, in the first element, is the property dedicated unconditionally to public use? We're going to look at how the public uses it, or if the public is benefited by the use of the property, and then whether there's some unconditional dedication of the property to this public use. And then that we're going to look at the organization's articles of incorporation, perhaps its bylaws, to see if there's a restriction on how the property of the organization is used, whether it's restricted as to transfer. Those are the elements, the things that we're going to look at first. So the third element actually in it is the property owned and operated on a non-for-profit basis? And again, what we are going to be looking at is the organization's documents. Has it filed for as a charitable tax-exempt charitable organization under Section 501c3 of the Internal Revenue Code? That would be helpful in determining whether the property is owned and operated on a not-for-profit basis. We also may look at the incorporation of the entity that owns the property and whether it is a Vermont nonprofit. So being a Vermont nonprofit corporation that owns the property and being potentially a 501c3 charitable organization would indicate that the property is owned and operated on a non-for-profit basis. The other element, the really difficult element often to sort out, is does the primary use of the property directly benefit an indefinite class of persons who are part of the public and also confer a benefit on society as a result of the benefit conferred on persons directly served? And that is the language, folks. It is very convoluted. What we've come to understand is that under this element, this prong of the test, the property must directly benefit an indefinite class of persons who are part of the public and thereby confer a benefit on society. This is to make sure that the use of the property benefits society as a whole, benefits the public as a whole, rather than a use that benefits only a select few individuals. The focus is not necessarily on the number of beneficiaries, but whether the extent to which the property is available to only a discrete segment of the public. So I think the best way to explain this is by way of an example. In 1979, an organization called the Trustees of Vermont Wildland Foundation was seeking a tax exemption from the town of Pittsburgh. This was for an undeveloped parcel of wilderness property in the town of Pittsburgh. The property was used primarily for scientific research by college-level students and professors at a nearby college. I believe that was Middlebury. So Middlebury students and Middlebury professors could use this, or were using this property for scientific research that they were conducting. But the owner of the property, which was not the college, the owner of the property was a private organization. It was Vermont Wildland Foundation. Strictly controlled access to the property and permitted entry on the property only if the persons who wanted to go on the property completed a detailed application. So the public couldn't just go there. It was only folks who were associated with the university who were doing, or the college that were doing scientific research. The Supreme Court said that the selection criteria, because it was so restrictive, could not allow the property to be subject to the public, pious, or charitable use exemption because of this very restrictive criteria of who could use the property. The court said that the beneficiaries of the use of the land are restricted to a small select number of students, professors, and researchers chosen by the plaintiffs, the property owners, for their own reasons. This is not a public use. So the general principle I think that we take away from this is if the property is used only by a select number of individuals who are required to use it only for specific purposes, then likely that property will not be subject to this exemption. There was a similar case in the town of Johnson. An entity called Vermont Studio Center operated an artist residency program. The Studio Center applied for an exemption for their properties in the town. The people who were attending programs at the Vermont Studio Center had to submit an application fee. They had to submit examples of their work, a resume, and 3 references. The Vermont Studio Center decided who could be part of the program and who could use the property. And that the Supreme Court held that because the primary uses of the property did not serve an indefinite class of persons, and because those who could use the property were finite and limited, the property was not subject to an exemption. Okay? And we might contrast this with an example from the town of Norwich. In Norwich, there was a property owner that operated a dairy farm that was open to farmers, 4-H organizations, ag students, children, the public at large. This was a demonstration farm, effectively. No one had to submit an application. No one had to attend an interview. It was open to the public to see what was happening on the farm and to learn about agricultural practices there. And the court said that because the farm benefited an indefinite class of persons, and because the specific individuals who benefited from the farm were undefinable, then therefore that property was subject to the public, pious, and charitable use exemption. So, as you can see, this is obviously has 3 elements. Those elements are very nuanced. It requires some very careful analysis. Oftentimes, even the best analysis may come up with conflicting results. So I would caution you to be conscious of this and careful of this exemption, and carefully consider the information that you get in your 317 form about properties that may be asking for this exemption. And just be aware and be careful. You also have to be aware and be careful because that's public, pious, and charitable use exemption is also subject to another statute that is 32 VSA 3832 that actually limits the application of the public, pious, and charitable use exemption. It eliminates some exemptions for property owned by a religious organization other than a church edifice, a parsonage, outbuildings. You can see the language there. So when we're looking at 32 VSA 38024, the public, pious, and charitable use exemptions, know that there is another statute, 32 VSA 3832, that limits the application of the public, pious, and charitable use exemption. Also under that statute, know that if someone applies for a public, pious, and charitable use exemption and that property is used primarily for health or recreational purposes, then in order to grant the exemption, there must be a municipal vote for the exemption to take effect. But also know that there is an exception to that, an exception to the exception. And also know that this exception to the exception applies to property used as a skating rink. So I think the principle there is if we've got a property that is potentially subject to an exemption, but is used primarily for health or recreational purposes, including a skating rink, we're going to need to do some additional investigation before the exemption is granted. Also, we need to keep in mind that there is another exception to the public, pious, and charitable use exemption that applies to property owned by fraternal organizations and volunteer fire and ambulance and rescue companies. My experience is that most municipalities are aware of this. So, real estate owned by a charitable organization, such as a fraternal organization or a volunteer fire and ambulance or rescue company, which is used exclusively for the purpose of such society, body, or organization, may be exempt from taxation for a period not exceeding 10 years if the town votes for the exemption. So if you've got property in your town that is owned by a volunteer fire department or a rescue or ambulance squad, and that property, the owner of that property has asked for an exemption, know that that property likely requires a town vote. The first exemption period is 10 years. After that expires, the town can vote additional exemption periods not exceeding 5 years. So takeaway is volunteer fire department, rescue squad, ambulance company, property may be exempt if the town votes first for 10 years, and then after the 10-year period, there have to be votes for each additional 5 years. There also is an important element to understand in the public, pious, and charitable use exemption, and that is known as or recognized as the nonprofit concurrence of mission. So what we might have in a town is a situation where a nonprofit organization owns property that likely is exempt under the public, pious, and charitable use exemption if that nonprofit were to use the property for its own purposes. But rather than use the property for its own exempt purposes, the nonprofit instead leases the property to another nonprofit, which has a different purpose. In that case, the property may not be exempt, because the Supreme Court has said when property is owned by one nonprofit organization and leased and used by another, there must be a concurrence of nonprofit ownership and use between the owner and the lessee, such that the two have a single mission. So if the mission of the two organizations, the owner of the property and the lessee of the property, are different, the property may not be subject to an exemption. The two nonprofits must have a single mission for the property to be exempt from taxation under that statute. If the concurrence of mission is not present, the property cannot be exempt, even if the owner and the tenant might otherwise qualify for an exemption separately. So in that situation, again, we have to look at the use to which the property is being put by the owner and by the tenant, and make sure that those uses are in furtherance of a single mission held by both of the entities. And I'm sure we're going to have questions on all of that.
We sure do have a couple of questions.
Okay.
All right, Walter is asking, does an exemption in Vermont have to file a Vermont domestic nonprofit? If so, can we skip to this document?
Just being a nonprofit, a domestic nonprofit, does not necessarily qualify the property owned by that nonprofit for an exemption. We also have to look at the use to which the property is being put. So that is essentially that is the three-part test of the three-part American fly fishing test. Is it owned by a nonprofit? Is it put to public, and is it put to public use? And is it dedicated unconditionally to that public use?
All right. Cora is saying, we have the Green Mountain Airy Lodge, or the Eagles Club, that has been voted to be exempt by the town every 5 years.
Yes.
Can we have them fill out the exemption form and, if applicable, change it to be exempt without the vote, or does that need to be voted on at town meeting?
Eagles Hall needs to be voted on every 5 years at town meeting.
All right. Charlie is asking, what kind of documentation should the listers have if their files or in their files to validify the exemption?
I would want to see the article. If we're talking about a public, pious, and charitable use exemption for a nonprofit organization, I'd want to see the articles of incorporation of that organization. I would want to see a copy of its bylaws. I'd want to have a copy of the deed if it indicates any restriction on the use of the property. Anything that would indicate that anything that would indicate in the documents of the organization how that property is owned and how the property is to be used, and any restrictions that there may be on transfer of that property.
Okay. And Jed is asking, part of the statute says forest and farmland cannot be exempt. How is this interpreted?
Forest and farmland cannot be exempt. Let me go back. I think we're going to cover that in a few moments as we go forward. So let me hold that one, and we'll get to it, I believe. Okay.
Okay. So Christina is asking, in respect to 32 VSA 38024, if only part of building meets the test, can exemption be applied to that part only? Should the town ask for the building to become condominium? That's a tough word to say.
Yes, condominiumized.
That's the one.
Okay. There could be a possibility that only a portion of a building or a property is subject to the public, pious, and charitable use exemption. So that is a possibility. The exemption may apply only to a portion of property and not to the whole property, depending on how the property is used. I don't think you need to go to the extent of requiring that the property be condominiumized or parceled out or subdivided, so long as the exempt portion can be relatively definitively determined. Okay. So, and what I'd want you to, like, let's say, for example, that the building is 10,000 square feet and 3,000, we've determined based on the use that only 3,000 square feet is subject to the exemption, then we'd want to have some reasonable way of determining which 3,000 square feet that is. But it doesn't have to be a legal document that condominiumizes or subdivides out that 3,000 feet.
Oh, I apologize, I was muted. Robin is stating Green Mountain Club is claiming a 501c3 through a deed. Would all lands owned by them be exempt?
I'd have to look at, we'd have to look at the use that the property is being, the use to which the property is being put. So the Green Mountain Club might have some property that is subject to the public, pious, and charitable use exemption, but it could have other properties that is being put towards some non-public use and is not subject to the exemption. So we can't look at it and say as a blanket matter, all of the property is subject to the exemption. We have to look at the use of the property.
All right, and that's all we have for questions again.
Okay. So rolling on, other categories of exemptions, and still within 38024. There is also an exemption for real estate owned by churches or church societies or conferences and used as parsonages. So property that is used as parsonages or as a parsonage by a church or church society or conference is subject to this exemption. The question comes up, what is a parsonage? The Vermont Supreme Court has said that a parsonage is commonly defined as a residence for an ordained minister who is serving a congregation's needs. It does not include apartments on church property used by the public or by visiting clergy. So it is that portion of the church's property that is used by a residence for an ordained minister who is serving the church or serving the congregation. Another exemption is for real estate set apart for library uses and used by the public in private circulating libraries open to the public and not used for profit. So in some municipalities, we have municipal libraries. In other municipalities, we might find a public library that is not operated by the municipality, but is operated by a private nonprofit corporation. That property is typically subject to this exemption, so long as the library is open to the public and not used for profit. There is an exemption for lands leased by towns or town school districts for educational purposes. This exemption applies to property owned by a town or a town school district and leased to raise money for educational purposes. And you might scratch your head and say, what is that? Well, back in the day, when most Vermont towns were granted, lands were set aside for the purpose of being leased by the town to support the operation of a town school or a regional school. That land is exempt from taxation, so long as it is being leased for that purpose. But by the passage of Act 60 in 1997, funds received by a municipality other than a school district may not be used directly or indirectly for educational expenses. Thus, under that statute, under Act 60, town-owned land cannot be leased to raise funds for educational expenses. So this is an exemption that if we're still using it in the state of Vermont, we probably ought not to be. It would be land owned by the town and leased to a private party, and the lease rental income being used to support the town school. Now, there is another exemption for colleges, academies, and other public schools that is still in effect. So lands owned by or leased by colleges, academies, or other public schools is it subject to an exemption. Now, the first question that might come up is, what does it mean by public school? Is this a public school, meaning a school run by a Vermont school district that is supported by taxation? And the Supreme Court has said no, that public as used in this exemption means an institution incorporated for the purpose of general education and operated without any intention of profit, not just those schools supported by public taxation and free to the public without charge. So we might have, for example, a private school that is operated on a nonprofit basis that is open and available to the public for attending, and that the property owned by that school would be subject to that exemption. Another element of this that you need to keep in mind is that the college or academy or public school must own the property. So if the property is owned by a private individual and leased to a school, to a public school, it does not qualify for this exemption. The property must both be owned by the college, academy, or public school and used by the college, academy, or other public school. It has to be used it has to be used by the school for educational purposes as well. So the Vermont Supreme Court has said that a headmaster's house at Burton Seminary down in Manchester qualified for this exemption, but a dormitory that was converted for commercial rental purposes did not. So again, owned by the school or college or academy and used for educational purposes. If it's leased out for private commercial use, it would not be subject to this exemption. And then there's another wrinkle on this as well, that if the property is owned by a college, academy, or public school is used primarily for recreational purposes by the public, it is subject to the exemption, it is subject to a different exemption and not exempt without a town vote. So this was the Middlebury Snow Bowl down in Hancock. Middlebury Snow Bowl was owned by Middlebury College. The question was whether it was exempt as land owned by a college under this statute. The Supreme Court said no, that this statute did not, the statutory exemption did not apply. A different statute applied that required a town vote. There is also another wrinkle on this, is that if a college or university acquired the property after April 1st, 1941, the property is taxable unless the voters of the municipality vote to exempt the property from taxation. So if the property was acquired after 1941, we have to have a town vote. And also, just a moment. I'm going to skip to that next part. Also, as we've said earlier, that we have to look at the use of the property that's owned by the college or academy or public school. If the property is used for a commercial purpose, it is not going to be exempt. Property owned by the University of Vermont is exempt from taxation under 16A VSA 1-15. So if the University of Vermont owns quite a bit of property around the state, you would want to check that in your grand list and confirm it is owned by the university. It is exempt. There's another strange exemption out there. Oops. Lands leased by towns for the support of the gospel. Many town land grant charters have lands reserved in them. That land was reserved to the town with the requirement that the town lease that land and use the rental payments that were received to support a church in the town, and that town was exempt by statute. It was held by the Supreme Court in the 1970s that this violated the First Amendment of the United States Constitution. Towns could not use these lease payments to support a church. And also, typically, towns have released their interest in these lands to the current tenant or lessee. So this is one that, while it's still on the books, you're not going to run across very often. So, any question on that group?
We do have one question, and to go back to the question about what someone might want to have in their lister file about these exempt properties, the PVR 317 that Christy included in the comments section, as well as the, let's see, I think it's called the CR 001, which is the insurance replacement cost of tax exempt property reporting form if you don't assess that property, and I will include that in the notes.
Yep. Let's make sure that we've got that 317 form in the insurance-based assessment form in that file as well. Absolutely.
All right. Jacqueline is asking, how does one confirm that a school open to the public is not making a profit?
What we typically are going to look at or whether it is incorporated as a nonprofit entity. The way that we can do that is we can go to the Secretary of State's website and do a business search under the name of the entity that's operating the school and see whether it is registered as a for-profit or not-for-profit corporation.
All right, and believe it or not, that was the only question that we have in the chat.
I can understand sometimes things are so confusing that folks don't even know what question to ask. But we're going to keep doing our best and keep rolling on. This is not often very simple stuff. Okay, but one that is typically a little bit simpler, the next exemption: buildings, land, and personal property owned and occupied by a young men's Christian association or a young woman's Christian association for the purposes of its work, the income of which is entirely used for such purposes. So typically what you're going to have, you're going to see here, if you've got YMCA or YWCA property located in your municipality, that property is going to be subject to exemption. Another common exemption: lands used for cemetery purposes and the structures thereon, trust funds and other properties belonging to or held by cemetery associations and the lots of the proprietors thereof. So, like libraries, we have municipal cemeteries in the state of Vermont, and we also have like libraries, we also have municipal cemeteries in the state of Vermont, and we have cemeteries as well that are owned by private nonprofit organizations but open to the public. The lands owned by a private nonprofit corporation and available to the public as a cemetery are exempt from taxation. Another relatively simple and straightforward exemption is grounds and property owned and occupied by agricultural societies, so long as the same are used annually for agricultural fairs. So if we have property that is owned by an agricultural society and they're using it every year for an agricultural fair, that property is going to be subject to an exemption. The next one that we're going to look at very briefly, because there is quite a bit of information out there about it, is the veterans exemption. Real and personal property to the extent of $10,000 of appraised value, occupied as the established residence and owned in fee simple by a veteran, is exempt from taxation. The best resource for learning more about this is the document that's put out by PVR, by the Department of Taxes, titled Veterans and Property Taxes: What You Should Know. It's available online. That is the best resource for figuring out the veterans tax exemption. Another exemption that you may not be aware of is an exemption for real and personal property exclusively installed and operated for the abatement of pollution of the waters of the state of Vermont. Now, this would potentially be a water pollution or water treatment plant that is not owned by a municipality. So it's not owned by a town or a fire district or a village, but is owned by a private entity. Potentially we might see, for example, a water treatment plant owned by a ski area. Okay, that may qualify for an exemption under this statute. There's also an exemption for approved air pollution treatment facilities under the statute that I've cited there below. There is an exemption for real and personal property owned by a charitable nonprofit organization devoted to the welfare, protection, and humane treatment of animals, including any premises of a custodian or caretaker which is attached to or located on the grounds of such animal shelter. So animal shelter property is typically going to be subject to this exemption. There is also a statutory exemption for real and personal property owned by a federally qualified health center or a freestanding federally designated rural health clinic. Now, the way that, in order to identify that, what I would suggest you do is go to the website that I've cited there. It will describe what a federally qualified health center or a rural health clinic is. And typically, if your property owner is one of those things, they will know about it and will give you the information on which to make the determination about that exemption. Coming down toward the end, you should also, and probably do know, that there is an exemption for renewable energy plant generating electricity from solar power, which has a plant capacity of less than 50 kilowatts and is either operated on a net metered system or B, not connected to the grid and provides power only to the property on which the plant is located. So this is typically going to be your small scale or residential net metered solar panels. If it's not net metered, it might be off the grid. They might be off the grid panels that serve only that property. 50 kilowatts is typically, I would say, on the order of about 6 times more larger than typical residential applications, so it can be pretty good sized. Okay? We're going to look at the nameplate capacity on the solar panels to determine what its capacity is, whether it's 50 kilowatts or under 50 kilowatts. There is also a opportunity for towns to vote to exempt renewable energy sources that are larger than 50 kilowatts, but that again requires a town vote. And you also should be aware that solar plants with a nameplate capacity equal to or greater than 50 kilowatts are subject to a separate solar energy capacity tax. So they're not taxed as real estate, they're taxed under that taxing formula. Real estate used in an operating railroad is exempt from taxation. It is subject to its own special taxing regime. This exemption includes the rights-of-way, freight yards, tracks, and any buildings that are still being used in the railroad, or that are being used in railroad operation. Buildings and facilities that are used for other purposes, non-railroad purposes, can be taxed locally. There's a good explanation of this in the Lister and Assessor Handbook. Also, coming up to the end of this, real and personal estate used in carrying on a telephone business or operating a transportation company in the state telephone business is exempt. This statute says that the purpose of this, the telephone property is subject to an alternative taxing methodology. It's just basically the statute says that the purpose of that alternate methodology is to provide an alternative to the traditional valuation method in order to achieve consistency across municipalities. Because typically the facilities are run from one municipality to another. There also, you should be aware of those 4 other exemptions that are listed there on the bottom of that slide. That's in total 25, and that's where we're going to wrap up. So are there any other questions about the last group or any of the other exemptions that we previously talked about?
I'm not seeing any questions in the chat, but Susan does have her hand up. Susan, would you like to unmute and ask your question?
Sure. My question goes back to the vets exemptions.
Yep.
It said in there a child. We had a vet who was getting the exemption. He passed away. His wife got the exemption. Now the daughter owns the property. Does that include her? Does the exemption follow?
Folks from PVR want to take a shot at that one?
Terry, do you want to answer this question?
I usually send them to VOVA, Veterans Office of Veterans Affairs. And I'm pretty sure they're referring to children under the age of 18. So
That's what prompted the question.
So feel free to call Veterans Office of Veterans Affairs, and he would know.
Okay.
We'll put the link in the information in the chat.
Okay. Thank you.
All right, thank you, Susan. Al is asking, is the maximum amount of veteran reduction valued at 10,000 or 40,000? Can you talk about that, Jim?
As I recall, I believe that the default is 10, but it can be voted up to 40 by the municipality.
Yes.
Okay.
Yeah. Jed is asking if we can go back to the question about forest and woodland can't be exempt. Jed, do you unmute and ask your question?
I believe there's another paragraph in the statute that says woodland and farmland cannot be exempt. Is that true, or how is it interpreted?
Let me just take a look at the language of the statute, and I need to go back and read it and just think about it a little bit. I see the clause that you're referring to in that statute, and honestly, I've not given enough thought about it or done enough research on it to be comfortable giving you an opinion or how to interpret that. I think what you are referring to, it says that the exemption of lands owned or leased by colleges, academies, or other public schools shall not apply to lands or buildings rented for general commercial purposes, nor to farming or timberlands owned or leased thereby. Is that the clause that you're referring to?
I think so.
Okay. I think the way that I would interpret that, and I'm shooting from the hip here a little bit, is that if we've got land owned by a college or an academy or a public school, and it's not being used for educational purposes by the college or academy or public school, but being used for farming or timberland purposes, then it is not subject to the to that exemption.
Okay. Let's see, the next question that we have is from Jacqueline. Does the town vote on vet exemptions expire?
My recollection is that it does not, but I'd ask that PD&R folks confirm that.
Terry's saying no expiration date.
Yeah, that's my understanding as well, is that once it's voted to something other than $10,000, it remains at that level, probably until if the municipality were to vote to reduce it back to 10, which is very unlikely to occur.
Right, and Terry's also saying that the first 10,000 is automatically exempt by statute,
Right.
but they have to vote on the additional up to 30,000.
Up to 30. Okay. Yep.
I'm sorry, additional 30 up to 40.
Up to 40. Right. Yep. And again, just to make sure we're on the same page, once it is voted from 10 up to an additional amount, it stays at that additional amount until the time the town votes it back to 10 or back to some other amount.
Right. Walter is asking, a church purchased a separate lot for the sole purpose of a food shelf that is open to the general public. Would this need be filed as a separate exemption, or would it fall under the churches?
I would ask for a 317 specifically for that property. And then I would look at whether when we say it's being operated as a food shelf, is it being operated as a food shelf by the church, or is it being operated as a food shelf by another entity?
Okay. Jody is asking, Catholic Church is no longer in operation. Original deed states land can only be used for church purposes. Is the diocese responsible for taxes at this time?
That's an interesting question. My inclination is to say that it's probably not subject to taxation. It's still probably exempt, but I'd like to, I'd have to do further research on it. Okay, basically, I think the question is if we have property owned by a church and the property is no longer used for religious purposes, but it's essentially just vacant, does it then become taxable? And my inclination is that it probably does not become taxable, but I'm not certain on that. We'll have to do some research on.
Okay, back to veteran exemptions. Is that vet exemption allowable only on the municipal tax?
TV&R folks, my understanding is that the veterans exemption applies to both the municipal and the statewide education property tax. I'm not sure if, does that also apply if the municipality has voted to increase the amount of the exemption?
Yes, it does.
Okay.
So yes, it does apply to both ed and municipal, Terry?
Yes, it does. Christy has a good explanation. If the town votes the additional amount of the veterans exemption, they are agreeing to raise the lost revenue for the additional amount voted through the local agreement rate. In other words, the town is paying the additional amount of education tax. The property owner doesn't have to pay it, but the whole town pays it in their tax base.
So it's treated as a locally voted exemption.
Yes, anything above the 10,000.
Okay, so just to make sure that we understand that, the first 10,000 is exempt across the board, municipal and statewide education property tax. If the municipality votes to increase it beyond $10,000, from the taxpayer's perspective, it is exempt across the board. From the municipality's perspective, the municipality still has to raise the lost revenue for that additional exemption amount, which is because it's still subject to statewide education property tax, right?
All right. So Allison is asking, if a college acquires property after 1941, it is taxable. If it builds new buildings on the property, are they exempt depending on the use?
I'm going to have to pass on that one, and that would require more, me to do additional research. That's one I'm not comfortable shooting on from the hip.
Okay, it looks like that wraps up the chat questions.
Deanna, this is Christy. Can I just bring up a point on the college piece?
Absolutely.
I think it's good for towns that have the colleges to really do an inventory and see which and what buildings they own, how they're exempt, and really dig into that, because I think it's a point of contention that we've missed over the years. So I think you got to really parse out each piece of that.
Okay, and I think we would also like to put in a plug that a lot of this information can also be found in your Lister handbook. It may not be as, what's the word I'm looking for, as lengthy as what Jim might provide in this class or verbally, but there's a lot of great information for you to reference there. So we do encourage you. That document was updated last year and it was expanded quite a bit. So even if you have flipped through that and read it before, we would encourage you to do that again. And I think that's it.
Okay. I just to follow up on Christy's last statement there, I would very much encourage folks, when looking across your entire grant list, if you have property that is exempt, or that if you have property that you think might be exempt based on what you've learned today or otherwise, it's well worth your time to go not only to the Lister's handbook and the materials that I've had, but you really can do some further digging, potentially talk to your town attorney and ask that attorney to look into it as well. A lot of these analyses are very nuanced, very fact specific. They turn not only on ownership, but use of the property. So it's well worth often investing the time and doing the research to know specifically about each one of these properties and whether or not it may be subject to an exemption. Okay.
Terry, do you have anything else for the class?
No, but if you look in your original email that you received, or received again, if like that, like I had said earlier, the information is in his documents also that he went through, and that's about it. I want to thank him very much for doing this, and it's very appreciated. And everybody in the chat is saying thanks and thank you.
You're all very welcome. Thank you, folks, for having me, and I'm glad that it was useful, and I just again thank you, and I hope everybody has a great day. Okay.
Thank you.
Okay. Bye, everyone.